The law is meant to be a shield for the vulnerable. India's highest courts have repeatedly affirmed this principle, especially concerning the rights of persons with disabilities. These judicial bodies have issued clear and unambiguous directives. They have instructed governments, they have instructed state institutions to implement the provisions of disability law without delay. The orders are not mere suggestions. They are binding mandates. They are intended to ensure equality. They are intended to ensure opportunity. Yet, a troubling gap persists between these legal pronouncements and the actions of authorities on the ground. In Jharkhand, this gap has become a chasm, trapping individuals in a cycle of uncertainty and injustice, despite the courts having clearly said yes to their rights. This failure of implementation is not an abstract legal problem. It has a profound and damaging human impact. It hurts real people who have placed their faith in the legal system for protection. Consider the case of a dedicated teacher serving a state university. This individual, a person with a disability, has been denied the basic security of a permanent job. The university, a public institution funded by the state, has chosen to disregard a long series of court orders. This defiance transforms a legal victory into a personal ordeal. The history of this case is marked by a clear pattern of judicial intervention met with institutional defiance. The courts did not just issue one vague order, they provided a roadmap for compliance which the university consistently ignored. A pivotal moment came with the Supreme Court's judgment, Justice Sunanda Pandare Foundation versus Union of India and Anaha, 2014. It was a powerful directive. It instructed central governments to enforce the disability law. It instructed state governments to enforce the disability law. It demanded enforcement in both letter and in spirit, immediately. It was a nationwide call to action. The Jharkhand High Court built on that judgment. It specifically named vice-chancellors and institutional heads. It made them personally accountable for implementing reservation rules for persons with disabilities. These orders were not left to gather dust. When compliance was not forthcoming, the court issued show cause notices for contempt. Yet the university treated repeated warnings and legal threats as having little effect and leaving the aggrieved teacher in perpetual limbo. Behind the legal arguments lies the story of a dedicated professional. He was not a temporary hire for a short-term project. He was appointed and served the university continuously for 7 long years. He performed all the duties expected of a regular faculty member. He meticulously prepared and delivered lectures. He developed curriculum. He conducted examinations. He graded student assessments. He was an integral part of the academic fabric of his department. Believing in fairness, he formally requested regularization. He did not simply make an emotional appeal. He built a case grounded in law and precedent. He submitted multiple representations to the university administration. He methodically outlined his situation. He cited laws protecting rights of persons with disabilities. He cited the mandate for reservation in employment. He included copies of key judgments from the Supreme Court and various high courts. The response was a profound and deafening silence. His representations were met with inaction. Reminder emails and follow-ups were systematically ignored. This was an active refusal to engage. For the teacher, the silence was administrative stonewalling. It left him powerless and unheard. The teacher's plea for regularization is not an isolated or novel demand. It stands on a solid foundation of judicial precedent established by the highest courts in India. The Supreme Court, in particular, has been a powerful advocate for the rights of persons with disabilities. In the significant case of Ravi Kumar Arora versus Union of India, the court articulated a crucial principle. The rights of disabled individuals cannot be postponed. The court stated that we cannot ask them to wait for the realization of their rights, which are guaranteed for today, not some indefinite future. This judgment dismantled the excuse of administrative delay and established a sense of urgency, ordering authorities to act decisively in favor of disabled workers seeking their rightful place. Further strengthening this position, the Supreme Court's ruling in State of Karnataka versus Vinod Kumar and others provides direct support for claims like the teachers. In this case, the court examined the issue of long-term contractual service. It held that when an employee has served for an extended period, performing duties that are permanent in nature, their claim for regularization must be seriously considered. The court looked beyond the contractual label to the actual substance of the work being performed. For someone like the Jharkhand teacher, with 7 years of continuous service, this judgment provides a powerful legal argument that his employment is, in effect, permanent and should be formally recognized as such. Beyond the Supreme Court, various high courts have clarified a critical aspect of disability rights. Reservation policies must apply to regular posts. Reservation policies must apply to permanent posts. These courts have reasoned that the entire purpose of reservation is to provide stable, long-term employment and economic empowerment. Offering only temporary or contractual jobs to fulfill a reservation quota defeats this objective. This line of reasoning directly challenges the university's practice of keeping the teacher on a contract for years. These judgments collectively create an undeniable legal momentum in the teacher's favor. The university's refusal to act is more than a simple administrative failure. It inflicts tangible and severe harm on the teacher. The most immediate impact is the immense psychological stress and anxiety. Living with the constant uncertainty of a contractual job where one's livelihood can be terminated with short notice is a heavy burden. This instability is compounded by the knowledge that his peers, performing the same work, enjoy the security of permanent employment. For a person with a disability, this manufactured precarity is particularly cruel. It undermines mental peace and creates a daily struggle that extends far beyond the classroom. Contractual employees are often denied the full pay scale, annual increments, other benefits afforded to regular staff. Over 7 years, this translates into a significant loss of income and a diminished capacity to plan for the future. The teacher is deprived of rightful earnings and the opportunity to build a stable financial foundation for himself and his family. Furthermore, the lack of a regularized post means his years of service may not be fully counted towards seniority or retirement benefits, effectively penalizing him for the university's own inaction and jeopardizing his long-term financial security. By systematically ignoring his letters, emails, and legally sound representations, the administration treats him as invisible. It sends a message that his work is valued enough to be exploited for 7 years, but his rights as a person with a disability are not valued enough to be acknowledged. Ultimately, the university's defiance is a clear case of contempt of court. The Jharkhand High Court issued specific orders to consider his representation, and the university failed to do so in any meaningful way. When court orders can be so easily flouted by a state-funded institution, it erodes the rule of law. The harm, therefore, extends to the public's faith in justice. The teacher's case demands clear and decisive relief to rectify these multifaceted harms and reaffirm that court orders are not optional, especially when they concern the fundamental rights and human dignity of a citizen.